Okay, well, we'll go ahead and get started because I know it's almost about 6:40, so I want to make sure that I honor everybody's time this evening. We are so grateful that you guys could join us for our educational webinar tonight. And it's going to be very great tonight we have Lucas with the World Financial Group and Genevieve as well. And they will be able to discuss a little bit more with trust fund planning. And if you guys have any questions, please make sure that you guys keep it for the end of the discussion, and they would be happy to help with any questions you have, as well as if you guys want to put it in the chat so that you don't forget, they can address that at the end as well. Otherwise, I will let Lucas take over and he's going to say a little bit, and then Genevieve will be doing the presentation this evening.
All right, hello everyone. I'm so glad that everyone showed up. Thank you so much, Miriam, and also Carlos, for this opportunity to share this really important information with people. Super grateful for that. I had the good fortune of meeting Carlos Quesada at a film screening for Under the Lights. That was a short film produced by Miles Levin, who's a member of your group, and yeah, so we just started talking, and we decided to do this presentation to share information with you. I'm with World Financial Group. We teach financial literacy and offer complimentary financial analysis for people to help them to develop strategies to reach their financial goals. And Miriam is with Intervivos, and she's really wonderful with estate planning and other those types of services. And she's really helped me and some people I know. And I really trust her. She's works with integrity and really cares about what she does and cares about her clients. So thank you so much for coming to teach us about this, Genevieve.
Thank you, Lucas. I really appreciate this opportunity. Thank you, Miriam, and thanks to Carlos as well for putting this together. I love to talk about special needs planning. So if you can see the screen, I call my presentation How to Train Your Dragon. And that's because of this little thing I'm going to share here. Let me see if I can. So I have a nephew. Oh, you know what? I'm screen sharing, but I can't get I'm not able to get my screen to go. Let's see if I push enter. Aha. Okay. So I have a lot of nieces and nephews. And one of my nephews is named Taylor, and he's on the spectrum. And so he takes things very seriously. So a few years ago, it's actually been probably about a dozen years ago, I had a conversation with him. And I'm known as Auntie Vive in my family. And so anyway, I said, Taylor, do you want to go see the movie How to Train Your Dragon? And he responded by saying, no, I don't have a dragon. I have a dog and I pet my dog. Okay, so he felt like he was covered, He didn't need to go see a new movie. He didn't need to expand those horizons because, really no need here. Okay, so in my professional capacity, I have a lot of people that I talk to, and I'll say, have you done your estate planning? And a lot of times people will respond like this: I don't have an estate. Okay. They'll say, I've got a house, a family with young children, including a child with special needs, a business, investment, property. I mean, they start listing these things, and I'm like, okay, you have an estate. The problem is that a lot of times we think that an estate means, the big iron gates, throw open, there's the mansion. If we don't have that, considerable assets, we don't think we have an estate. Well, an estate can be really big and it can be really small. Okay. So when I first started as an attorney, I'd been licensed to practice law for 2 months, and my cousin, who was 29, suddenly passed away. He got a blood clot, and it was like absolutely unexpected, just out of the blue. Okay. And up until that point, I mean, when I was in law school, I didn't think estate planning, what an amazing, interesting field. But when Sheldon passed away, he didn't have any documents in place. He owned a business. He was married. He had 4 little children. And he didn't have any business succession planning done. I mean, there were just lots of things he didn't have in place. I went down to the little town where he lived, and I worked with an attorney down there who got everything set up so that his wife could actually sell the business, so that we had to work out. I mean, this is kind of a funny thing. He was an artist, and he had all this artwork, and there were questions like, does the artwork belong to the business? Can his wife sell the artwork? Can she, copyright this? I mean, there were really interesting things that I would never have been able to, foresee in law school, that this is a very dynamic and interesting part of the law. And it's something where everybody has a need. Now, I've mentioned that Sheldon had certain needs. And I will say this is a shout out to Lucas. One of the things that Sheldon had in place was life insurance. And you better believe me, that was such a difference for his family. It wasn't a huge policy, but it was, a considerable amount. And it really helped, when, to have something sudden like that happen, it really helped to have that, to be able to bank that for the future. So anyway, when I think about now, I realize that there are young people who are traveling nowadays. They may not own a home. Maybe they live at home with their parents, or they're just renting, they're in college or something. But there's a lot of travel that happens. It's a really good idea for kids to have their estate plan, which is some documents like a power of attorney and healthcare documents. Okay. That might be everything that they need for their estate. Okay. So, but your 18-year-old may need a power of attorney and healthcare documents. So there's little tiny things that people might need, and then there's bigger things. And we're going to talk about some of these bigger things. So, like I say, every family needs a plan. And most families need a trust plan rather than just a simple will. I think the word is kind of getting out. When I first started practicing, which was, 15 or 16 years ago, it was very interesting to me. People would always come to me and say, oh, I don't need a trust. I just need a simple will. And then they'd explain their situation, and I'd be like, why? Who told you needed a simple will? Oh, I just figured I just need a simple will. I'm like, no, a lot of times your situation needs something more. Now, as the years have passed, people have gotten more, more knowledgeable about trusts. And I think there's a lot more recognition of the important role that a trust can play in your estate plan. Now, proper planning should include the following 3 things. There should be a life plan, a transfer plan, and a family plan. So your life plan, you have documents that you're going to use throughout your life. You should be planning. There should be retirement things. There should be all sorts of things for your own life. Okay. Then a transfer plan, how are those things going to be transferred? Who are they going to go to? And then the family plan, that encompasses quite a bit. And I'm not sure how much we'll get into that tonight, but the family plan is, we really like to keep families together, keep families from breaking up when a parent dies, especially. That happens a lot of times. There's family feuds and all sorts of stuff. So we like people to do their planning so that your family can, hopefully still exist after you pass away, that can, go on, and the values that you've taught your kids can continue on. So let's talk about the timeline for special needs kids. Now, from birth to age 18, normally they're under the care of their parents, and they're often not eligible for public assistance benefits because the government will look at the parents' income when they're deciding on eligibility. And a lot of times, you know, they just don't qualify. Now, once the child turns age 18, then parents' resources will end, and the child might qualify for public assistance because they're going to look at that child's income. And if the child is not, able to work or not able to work very much, then they will probably qualify. Something to keep in mind, and this is hard sometimes for parents to wrap their minds around, is that their authority to make legal decisions for their children ends when that child turns 18. And a lot of times we think, oh, well, yeah, I mean, I know that, for a neurotypical child, somebody who, doesn't have any extra needs, this person, I can see they're an adult. But if you have a child who, perhaps is, delayed or, something like, I know I have quite a few clients whose their child's, like developmental age might be 12 or 6. They might think, and even some who, their children can't communicate at all. They're like a baby. Your authority to make legal decisions for your child does end, no matter what their abilities are, when they turn 18. Now, obviously, if your child is, at a, like a baby and they can't communicate at all, there's going to be deference given to parents because the parents will say, well, this is what, the child needs or things. But there are times where your child might be like, if your child is, kind of maybe a 12-year-old, developmentally, they are going to be able to probably express their wishes, but they may not have that, be at that point where they should be making decisions for themselves, or at least not all of their decisions. So one of the things that you will want to consider if that is your situation is, should I get a power of attorney for my child? Should I do conservatorship for my child? What about a supported decision-making agreement? There are quite a few different tools that can be used for you to be able to help your child. Okay. Now, here are some planning mistakes. A lot of times when people come in to talk to me, they have heard that if their child with a disability receives an inheritance, they will disqualify for government benefits. So the solution seems to be, let's not give them any money. We'll disinherit them. And then that way they're not going to disqualify. And that may be true. I mean, maybe don't, you disinherit your child, they're not going to receive an outright inheritance. And so, they will not disqualify. But if you think about it, it's like the level of, like the standard of living that you receive as an individual when you are wholly dependent on government benefits is more of a subsistence level. And that's not normally where we want our children to be. Okay. As long as you're alive, of course, your child could live with you, or, you can, manage things for them. But when you're gone, if that is all they are depending on is government benefits, they are probably not in a position that you really want them to be in. Okay, now another thing, and I probably should put this as the first thing, is not putting things in writing. This is a really interesting thing. And to me, it is that I have lots of clients who think that if they put things in writing, it's like, if I write down what I want to have happen when I pass away, I'm going to die. And it's like, you know what? Writing it down doesn't mean you're going to die. That it does make you think about things, and you have to think, okay, well, what do I want to have happen when I pass away? But it's not going to lead to your death. Okay. But there's also this thing about, if it's not in writing, it doesn't exist. So, you can talk about, a lot of times we, talk to our friends, talk to our, grown-up children. We say, this is what I'd like to have happen when I pass away. That's great. I believe in being very transparent. I think you should talk with your kids, talk with your spouse. Everything should be, out there. But the fact is that it doesn't matter how many times you've sat around the kitchen table and said, when I pass away, I want you guys to all remain friends. I want everything divided evenly. If it's not in writing and you've done some interesting things with your assets, then it may end up that there's one child who ends up, scooping the lot, or one child who gets left out, or so you need to put things in writing for them to actually exist, okay, for them to actually happen. Now, this not planning around benefits, this is the reverse of disinheriting the child. Sometimes parents don't even consider what might happen if their child receives an outright inheritance. And so they're not planning around those benefits. Their child is receiving government assistance. They receive an inheritance outright. That inheritance may end up just being wasted. And in the interim, the child, and I'm not talking about even a spend down. It might just be that the child gets the money and, just goes off and takes their friends out to eat, or, buys a truck or a motorcycle. I could tell you stories about motorcycle, but anyway, there's this thing of not planning around those benefits. And even though they may not be a huge, your child might not be receiving a huge amount of money, but the medical at least is really, that's substantial. That's a really important part of benefits. And you don't want your child to disqualify. Now, another mistake that we see quite often is relying on your other children to provide for the child with the special needs. Now, this is an interesting one because, a lot of times we have, we have a sibling who has special needs, and there's another sibling that's very close to them that is always taking their part and, very much, helping them out. And so it seems like it would be, just kind of a, obvious that you can, let's say that Johnny has a disability and Jimmy is the brother who is always just helping him out. Seems really logical to just say, hey, you know what? I know that Jimmy, he's always looked out for his brother Johnny. This is, I know that's just going to continue on. And it may continue on. But on the other hand, Jimmy might get married and he might marry someone who doesn't actually feel that loyalty or concern for Johnny. And, things can take a turn for the worse. And it does happen, unfortunately, that in-laws don't always like our family as much as we do. So that is something that you want to be aware of when you're doing your planning, that, you can't just say, okay, and this is another thing that people will do is they will say, I'm going to give Jimmy Johnny's portion. So I'll leave it to Jimmy. And then we'll have this conversation where I say, Jimmy, I'm leaving you a double portion. So, you just on the understanding that you're going to, help Johnny out, and you'll use that, half of that for Johnny. And, crazy things can happen. Let's say that Jimmy does get married and he, gets this inheritance and everything gets all mingled and it's all marital, and, he gets divorced. There is a very real possibility that Johnny's inheritance will walk out the door with the ex-spouse. You can see there are lots of different scenarios of ways that things could happen that will mean that Johnny does not end up benefiting. Okay. Now, let's see. Okay, is this really the... Okay, yeah. Okay, so here are some main issues. When you start planning, and this is always very interesting to me, when you're talking about special needs planning, there are two different perspectives, because you're talking about the parents planning. So parents need to have their plan. And then you're also talking about the child's plan. Okay. And so a lot of times people will say, well, whose planning should we do first? Should we do our child's planning first? Should we do our planning first? Generally, I recommend that parents do their planning first and put in, depending on, where they are, put in different planning tools for their children. But it's really important. It's like when you're on an airplane and they give you the little thing of, hey, if the oxygen mask drops down, put yours on first and then put the mask on your child. Okay, so there are certain things that if you haven't dealt with them in your plan, it's really going to harm your child, even if they have a plan, or they, because a lot of people have heard of special needs trust. Even if your child has a special needs trust, if you don't have a will and you haven't designated a guardian for your disabled or, minor children, your family is going to experience a lot of hardship. Okay, so I generally will recommend that parents get their plan in place. So the main things that you're going to look at will be, you'll make sure, okay, what assets do we have? How are these going to be held? For example, with real property, we usually want people to have a trust, and we want the trust to own the real property. Because if you have real property in your name and you pass away, then your estate will have to go through probate. Okay, and some states are worse than others when it comes to probate. And I think, California is pretty proverbial for having some pretty strenuous probate issues. So, and then like life insurance, a lot of times people, they have their life insurance, they will put, and this is a way that that individuals will disqualify, because their parents will put, spouses as primary beneficiaries, and then they put the kids as secondary beneficiaries. And this is one that can actually be a bit of a surprise to people when they have minor children. So you put those kids as the beneficiaries. If you have minor children as beneficiaries, the life insurance will not pay out money to a minor child. They will tell you, they'll send you a letter, and it will say you need to get guardianship over your child. And if you're the parent, you will say, I'm my child's legal guardian. She's 9 or 12 or whatever. So obviously I'm her guardian and I just want to receive this money. That's not what the life insurance is talking about. The life insurance is telling you that you have to go to court and become the court appointed conservator of your child's, money. And what that usually means is that the judge is going to order that this money will be held in a federally secured account, conservator account, and not touched until your child turns 18. Okay. And that's not always the best. I said that I have stories about motorcycles. So my sister is a widow. Her husband died about 6 years ago, and they had 4 little kids at that time. And the kids they didn't receive life insurance, but it was a benefit that was an education benefit. It wasn't a huge amount, but they each got about $20,000. And they couldn't, my sister couldn't figure out, wait, I'm their guardian. What am I supposed to do? So we figured it out and went to court. And her youngest is now 15. Her name is Sky. She is this tiny little runner girl. Okay. She's a long distance runner. And she is determined that when she turns 18, she is buying a motorcycle and she's going to drive off into the sunset and see the world. Okay. And my sister is always telling her, Sky, this is not, you don't want to do that. It's dangerous. She'll, every time there's a motorcycle accident or something, she'll be, Sky, do you see this? Do you see how unsafe this is? I mean, you can imagine some young girl in a biker gang, that's really not what we want to have happen. I mean, maybe some of you do. I was talking to a client a few weeks ago and I said this, and there was a pause and he said, I have a motorcycle. And I was like, okay, nothing against motorcycles, nothing against them, not really. But if you think about it, there are other things that my sister wants Sky to do with that money. And if it had been left a different way, if it had been left to the trust, then the trust would have said, okay, here are the terms. Number one, Sky, you're not getting $20,000 when you turn 18. You're gonna, and any money that you get is going to go to your education. We're going to pay it to the school. I mean, there's so many terms you can put in a trust to just tie that up and lengthen out the money and stuff. And you can really say, I'm attaching some strings here. I'm not just going to give you the money to go out and join the motorcycle gang, So anyway, where was I? I'm sorry. I just kind of off-roaded on a motorcycle there. So I'm going to get back on track here. So minor and disabled children guardian designations. This is one that is so important. A lot of times, so I actually had a friend a few years ago. I'd given some presentations and she'd been at a couple of them, and she would always say, it is so important that you designate a guardian that you have of your minor children, that you say, you've got a will and it spells it out clearly. And finally, I thought to ask her, why are you so passionate about this, Annalise? And she said she had this friend who was just determined. She said, I cannot stand my brother. I would never want my children to have anything to do with him. I guess there was some bad blood there or something. And she was like, she would always say, he is the last person on earth that I would ever want to have raise my children. I mean, he just had all these problems. Well, she and her husband were sitting, and I've asked Annalise about this. It sounds so improbable, but she swears this really happened. Her friend and her friend's husband were sitting in Adirondacks on vacation at the lake, and they got struck by lightning and died. And they did not have a will in place. They had not designated guardianship. And this friend's brother is the one who petitioned the court for guardianship and was granted guardianship over this woman's kids. Okay, so you have to think to yourself, who is the last person on earth that I want to have in charge of my children? If I don't put things in place, that person may petition the court and they may get guardianship. Another thing that can happen is just that there can be too many people who are interested in your children, and it can end up being a fight. You can have a family feud. A few years ago, we had a kind of a high profile accident, and this young couple passed away. The two sets of grandparents got in a big fight. The one set of grandparents were actually living at the home of the parents, and there were these two little kids. I mean, they were little, like 2 and 4 years old. The other grandparents came to visit, and they took the children when they left, and they absconded with the kids. And there's still ongoing a big lawsuit about which set of grandparents is going to get these kids. Okay, so you can have people who are very well-meaning and you love them very much, and they might create a lot of problems if there is no clear designation of who should be, the guardian. And I always tell married couples, you really want to make sure that your wills agree. If you die together in an accident, let's not have, wife saying this, husband saying this other, because then we're looking at some litigation. So let's avoid that. Then there's whether you should get guardianship of your adult disabled child. That is another issue. And then, and that one, yeah, that is such a personal. I will just say this about guardianship. I'm probably not going to talk as much about it, like guardianship of an adult child. It's a very sensitive area, and it's something where you want to be very transparent with your children, and you want your children to be able to be very transparent with you. because you are talking guardianship is you are taking somebody's rights away. Okay, so there's when you have, if your child has the capacity to give you power of attorney, they can sign that, they're competent to sign that. That is a very good way to go. But it doesn't remove their rights. So your child still retains the right to make financial decisions. It's the same with healthcare. They still retain the right to make healthcare decisions. They're just giving you permission to act. Guardianship is different, or conservatorship is different, because it literally removes the rights away from an individual and gives them to another person to act in their behalf. Okay, so it's something that can be very sensitive. Okay, now the next one is parents' disability. So the parents, and this is something that, a lot of times you're spending the time as parents taking care of your children, and it's easy to forget that there may come a time when you are going to need that care. The power of attorney, the healthcare power of attorney, those documents, and then guardianship, those are things that can happen or can be needed, as we age. So this is something to keep in mind as this end game, is that your plan needs to address the possibility of you being disabled. Okay. Okay, and then when you're establishing your child's plan, you want to think about, how are they going to live when I'm gone? If I'm no longer in the picture, who's going to be there? Who is going to be the person or persons who are going to, help my child navigate? There are many different kinds of trusts. Usually we'll talk about the testamentary, first party, or third party special needs trusts. And then powers of attorney, healthcare documents, and then conservatorship. Okay, so we're going to talk about special needs trusts. Okay, the benefits of a special needs trust. First of all, it protects eligibility for government benefits. Okay, so money that's in a special needs trust, goodness, have I been taking all of our time? Wah! Okay. It provides for the higher quality of life. Like I was saying before, if here you have the subsistence level, you're receiving the government benefits, you've got that medical component, which is so important, but you're just making, getting a little bit of money from the government. If you have money that can come to your child through that special needs trust, it's going to raise that quality of life, which is what we really want to do. Okay, it provides a framework for care and for management of assets. It allows the parents to express their desires, protects assets from creditors and predators. This one is really important. Okay, and it extends the life of assets. Okay, or it can, depending on the kind of trust that you have. So first we're going to talk about the third party special needs trust. This is the special needs trust that most people are referring to when they say special needs trust or supplemental needs trust. This is the gold standard. But what I want you to keep in mind is that although this is such a great trust, there are other kinds of trusts that may be, I like to think of them as different tools, because we have different scenarios, and sometimes you can't use a third party special needs trust. And in that case, you might be able to use a first party special needs trust. So not to just get hung up on, I have to have the third party special needs trust, but to recognize there may be scenarios that wouldn't fit. The main details are, trust assets are not available to the client, meaning they're not available to the individual with the disability. They are there to benefit them, but the trustee is the person who doles those out, and usually for services, for things, not directly to the individual with the disability. And that's part of keeping the eligibility for government benefits. Okay, the trust assets are considered exempt for qualifying for Medicaid or SSI, Medi-Cal or SSI, because they're not owned. There's no direct ownership between the individual with the disability and the assets in the trust. So what that means is the money, whatever assets are in this trust, they cannot have a connection to the individual with the disability. They can't be a settlement amount that was, for this individual. They can't be, something that has been received by them that is theirs in their name. Okay. It has to come from, the parents or, family members, something. It's a third party. Now, the government cannot exercise estate recovery when the individual, so here is something that the government can do. When the individual with disabilities passes away, the government has the right to do government estate recovery. They can go to that individual's estate and they can recover the sums that they have dispersed over the course of that individual's lifetime. Okay. Now, because the money is in a third-party special needs trust and it belongs to someone else, it's not considered accessible. So the government cannot go in and pay themselves back out of a third-party special needs trust. The beneficiary can't revoke the trust and they don't have the power to compel a distribution. And those that lack of ability to revoke or compel distribution and that the assets don't belong to that individual, that is what helps them maintain their eligibility. Okay, now a first party special needs trust is different. The first party special needs trust, the assets are actually, they have a direct connection to the individual with the disability. This is we usually see this in like a settlement. There's somebody's, received a settlement because they had, some accident, something like that, and they get a settlement. So they receive, let's say they receive $100,000. They're going to obviously disqualify for receiving government benefits when their asset limits are $2,000. So they can put the money into the special needs trust that is a first party special needs trust and still qualify, okay, for Medi-Cal and SSI. What they can't do is that money is not protected from the government. When the individual with disabilities passes away, the government can go in and pay themselves back. The beneficiary can contribute to that. Obviously, their assets are the ones that go in. Sometimes they can revoke the trust, and sometimes they can compel a distribution of assets too. Okay, Miriam, do we have time for me to do the ABLE account real quick?
Yeah, absolutely. You have time.
Okay. So ABLE account, this is something that I feel like this is really super great, because this is actually, this is a way that an individual with a disability can save money and not have it, disqualify them, which I think everybody should have the right to save money. It's really hard when you are told, okay, you can't have over $2,000 in assets, or you're going to disqualify, and you really need to have, these benefits, but you'd also like to have that ability to save. You don't want to be always spending up to the limits of your income, and so I feel like this is like a really respectable thing, and it's something that is really, really awesome. So basically what it is it's an account that an individual with a disability can put money in, and they can still qualify to receive government benefits. They could receive it goes along the gifting limits. So it's usually about $15,000 from sources that are not the individual, can be put into the account on a yearly basis. Okay, so let's say you've got doting grandparents and they want to give you money. Now, I probably wouldn't recommend that they put it in an ABLE account. I would say set up a special needs trust and put it in there. But let's say that they wanted to give you money that was really liquid, something that you could access. So they can put it in that ABLE account and, you know, you can draw on that. Now, the other thing is that you, as the individual with the disability, can also contribute money. And I think it's pretty close. It's like 14,000, you know, that you can contribute on a yearly basis. Not that most of us have $14,000 to contribute, but just saying you can contribute money too. And the limits are, you can get up really close to, like, in some places it's 300,000 you can have, or 100,000, and still qualify for receiving government benefits. Now, one of the downsides is this is an account, okay? So you can't hold real property in it. It's not something that, you know, parents, if they buy a house, are going to, you know, have it owned by this account. They can't do that. And the other one is that government estate recovery applies to the assets in the account. So the government is going to be able to come in when that individual passes away. The government can come in and pay themselves back from whatever is in that account. So in that respect, obviously, it's not, you know, it's not the third party special needs trust where, you know, you can put a residuary beneficiary that's, you know, a different family member or something. This is, it's, the government has access to this. Okay, and I think that is about, I think I've discussed almost everything. Ooh, one last thing, the testamentary special needs trust. One of the things that I often talk to parents about is, so let's say that you're getting your estate plan set up. You want, down the road, you want to get a special needs trust set up for your child. But right now maybe it's not in the budget. Maybe, you know, you don't see a need. But you want their, you know, you want that at some point. I usually recommend that parents would have within their own trust, special needs trust provisions that say this child with the disability will receive their inheritance through a special needs trust. And the provisions are basically the instructions for setting that up. And it's like permission or authority to do that. It can be a sub-trust. It can be a little confusing because it can be a sub-trust of it, or it can be just the, you know, the instructions to, hey, go set this up, you know, once we pass away. The reason for doing that may be that you don't have assets that are going to fund that trust until you pass away. And, you know, so maybe your child doesn't need to have one right now. As I was mentioning before, if you have, I always call it the doting relatives, you know, because a lot of times you'll have like grandparents or aunts and uncles who are doting on your child, and they're like, oh, I'm going to make your child a beneficiary of my life insurance, or, you know, of my trust or something. And it's like, that is awesome. We just love that. But just hold on. What we'd really prefer you to do is use a little bit of that money and set up a special needs trust, and then fund that, you know, say, okay, now the life insurance, the beneficiary of the life insurance is not our child, it's our child's trust. And so, you know, that way your child doesn't disqualify, but they can get a nice fat inheritance from the doting relatives. Okay. So, but if you don't have that situation, then it's like, okay, this may be, you know, maybe something that you just put in those special needs trust provisions. And then later on down the road, if the need arises, then you'll do, you know, do a standalone third-party special needs trust. So, okay, you guys, phew, I've just talked my head off. So let's see, do people have any questions?
I have a question.
Yeah.
This is Priscilla O'Shea. Thank you so much, Genevieve. It was very informative, and we need to do this more often. We have a lot of people I was thinking that should be here. But I wanted to ask about that last piece where you show the annuities and there's beneficiary limits. What is that?
Okay. that one is, and I guess I don't need to go back to it. Basically, so let's say that you're, there can be income limits for receiving government benefits. So if your annuity is set up and you're receiving, a certain amount every month, it can be too much. And so you do have to be careful with that. You also have to be careful. I just recently had a client who, she received an inheritance, and it was, they put it into an annuity, and she can't qualify. It's not a huge amount of money. It's under $100,000, but they count that as an asset. And so she's kind of in this hard position because she can't take it out without penalty for 7 more years. And she's just, like, that's something that I would have said, let's put this in a first party special needs trust. It's obviously, it's a settlement, it's yours, so it can't be a third party special needs trust, but let's put it in a first party special needs trust. You'll qualify for benefits and that money is accessible. So, sorry, I think I answered your question, but I also went off.
That's okay. No, it was good.
Okay.
So basically there are income limits if a person or the trust is the beneficiary on that annuity.
The person.
What if the trust is the beneficiary?
Is it the third party special needs trust that's the beneficiary? Well,
Yeah, we have a case.
Party.
I can tell you, we have a case. It's two elderly sisters. Their mother passed away. They sold the property, but they are receiving benefits. So would it, they have this money that they haven't taken yet from their other sister, who's the trustee that liquidated the asset.
Okay.
So how do they set up something
So
like that?
let me ask you this: Are they disabled? How old are they?
Elderly, low income, 60s.
Oh, was there anything in the? Okay, so there's so many details that I'd need to go over. Like, is that trust? Did their parents' trust say anything about how the money would be? Should go
Equally distributed to the 6 children, and there wasn't anything in place. So they're both on low income housing and Medi-Cal or Medi-Cal. I don't think they're 65 yet.
Oh,
To the siblings.
how much is the money? Like, is it significant?
Each is receiving about 150 to 175,000.
Wow. Okay, that's wow.
So they're trying to, the question is, they were told an asset protection trust. And then the question is then, where does the money go?
So are
Does
they
it go into an annuity or?
Probably. So let's say they put it in an asset protection trust. Who is going to be the trustee on that?
Third party, their adult daughters.
Their adult daughters. I'm curious if that would pass muster, just because it's not supposed to be somebody who's subordinate, and an adult daughter would probably be considered subordinate. You know what? Why don't we?
I'll have to call you.
Yeah. This is something I'd like to, get all of the facts and go over that, because it sounds like it would need some creative, planning for that.
Okay.
That's very interesting.
Definitely. We'll contact you.
Okay. Yeah.
Thank you.
You're welcome. Now,
Wow, well, so that was really good. I mean, we covered so many different things. Thank you so much. And it really, I've been studying this stuff and I still just keep learning more and more things all the time. It's just amazing, like, how versatile the vehicle of trust really is.
now there was a question in the chat. How would a special needs trust worker be affected if the disabled minor or 18, 19-year-old received an inheritance from grandparents? So this is the same thing. How did they receive it? Like, did they receive it as, directly, like it was left just to them? Or was it left to the special needs trust? So if it's theirs, then it's going to be a first party special needs trust, most likely. If it's left to the trust itself, then there should be no issue with it, because it would be a third party, funding it with their own assets, not the individual's assets. Is the person who asked that question, is she still on?
Yes, I'm here.
Okay. Is that Wendy?
Yes,
Did I answer your question?
I think so. I think I was mostly wondering sort of what advice should be given to grandparents as they're planning who
Yeah.
their beneficiaries are and want to leave something to grandchildren. Should some specific advice be given to them?
Yes, absolutely. This is a thing you really, and it's funny because sometimes you can talk to your parents about it or the in-laws about it, and sometimes people are so funny about money. But if you can have an open conversation, it should always be centered on, look, we want to be able to keep our child's, eligibility. And if that, and sometimes people frown on others receiving government benefits. So it can even be just, I don't think that they could manage money very well. So we would like to have it, instead of leaving it to them outright, could you put in your trust or put in your will directions saying, it's going to go into a special needs trust? Or would you be willing to set up a special needs trust and then just make that the beneficiary of your trust, in place of the child? So it really is like, a few years ago, we had this crazy thing. It was like, oh my goodness, we had a client who, her parents had set up a special needs trust for her. They had funded that, when they passed away. She received her inheritance through it. It was perfect. She, had that, it raised her standard of living. She qualified for government benefits. And then she had an aunt who really, really loved her. And she left her, she made her the beneficiary of a life insurance policy. And she got this big old chunk, I don't know, it was like 200,000. And we were like, are you kidding? Like, everything is set up. If you had just changed that beneficiary, like just done a change of beneficiary form and put the name of that trust instead of your niece's name, there, it would have been no problem, but now she's going to disqualify. And so, that was a situation where it was like, okay, the tool we need here is the first party special needs trust. So we had to do a second trust for her just to hold that money so she wouldn't disqualify. But it just can get, if you can have, I just feel like if you can have a frank talk, that's going to be the best way to just say, look, here are the options. Here's how you can do it. You can put in some provisions in your trust, in your estate plan that say, this child has a disability. We want their money to be received, in or distributed into a special needs trust. Or you can, set one up and, or the parents can, and then just have that be the beneficiary. But it really, it's funny. People want to do good. But sometimes it can go awry. So. Oh, okay. Jay Curado is saying, could you go over why parents would set up a first party special needs trust over a third party special needs trust and what the pros and cons would be? The child would be over 18. So basically, this is going to really be fact sensitive. Essentially, if the money is the child's, they have received it outright. That's the same thing that Wendy was talking about. If the grandparents or somebody has left an inheritance to the grandchild, And there's nothing in there. Like usually I would like comb over that trust and see if there are any terms in there at all that say, and okay, and I will say this, something to be aware of whenever an estate is being settled or going through probate, if there is ever anybody who is disabled who is involved in that as a beneficiary, it is super important to have an estate planning attorney who does special needs involved. Because when you're doing the settlement talks, I mean, a few years ago, I came in on the tail end of this thing. It had gone on for 7 or 8 years on settling this estate. And I think it wasn't a huge amount of money, but this woman who was disabled was receiving about $100,000. And there was language in the will that said that she was disabled, that her mother didn't want her to receive her inheritance outright. It had all of the language that would say, this is a third party special needs trust. But they just kind of, the lawyers had talked it over. They didn't have anybody who was really up on that. And so they agreed that she could have $25,000 put aside in a special needs trust rather than the full amount. And it was really, it was just like that shouldn't have been. It should have all gone into, because of the language there, they should have agreed and said it's all going into this, into a special needs trust, a third party one. So, and I don't know why I got off on that, but anyway, but if you have, when the child receives that inheritance outright in their name, it says, I leave little Johnny $50,000, he's 18 or whatever, even if he's younger, I leave this to him outright. That's a first party special needs trust because it's his. He has received it. It's his money. It's when they leave it and they say, the third party is the one where it's funded by somebody else's assets for that child's benefit. Was that clear? I kind of feel like that wasn't as clear as I wanted to be. I apologize.
Basically, I think what you're saying is if something is specifically the under the ownership of the person with disability, then it would want to be in. There's still protection that individual
protection
can get from putting it into a first party trust for themselves. I have a question because we've been talking a lot about like the funding of a trust, but I know like a lot of people, with disabilities have someone who cares for them, right, in a very particular way.
Yeah.
And a lot of times, I think that could be, it takes it's a very special relationship that it takes to like give them just the certain kinds of care that they need, like maybe very specific things about the medication, or I know with epilepsy, a lot of times issues that can happen during sleep, right, for someone, and things like that. So what about the ways you can use trust to sort of, give instructions, very specific instructions about what a person's needs are?
That is a really important part. And I'm glad you brought that up. I used to spend quite a bit of time talking about that because that is a care plan. And you can have a care plan as part of your trust, and part of a special needs trust. And it is what Lucas was saying. It is specific instructions. And one of the examples I use is that, my nephew Taylor, he's on the autism spectrum. And when he was at school, I think it was second grade, he kept having these total meltdowns at lunchtime. And he had a really hard time communicating his needs. And we finally figured out it was all about the red tray. The school was a very large school. It probably had 5 or 10 red trays. All the other trays were white. And Taylor wanted a red tray. Okay. So that's something that is very specific to him. Okay. That's something that would be listed in a care plan. Just, you know what? Taylor likes the red tray. So, please give him a red tray. Or his younger brother, Grant, is also on the spectrum, and Grant has all sorts of sensory issues. He hates flies. It's just crazy. But when he was in preschool, when he was 4, we'd take him and drop him off. This is my twin sister's sons. We'd take him and drop him off class, and he would scream and scream and scream. And it was all about the blank TV screen. The snow that makes that sound if the TV's turned on and it's snowy, and it goes and it makes this loud noise. That was so terrible to Grant. We finally figured it out, but he couldn't communicate, and so it took forever, but we finally figured it out. And we had this put in his IEP that, which, kind of has a care plan aspect, that basically said, look, he can't handle that. You have to they put a blanket over it. It was just put a blanket over a TV screen if Grant's in the room. So it's things like that that can be really super particular to that individual. But if you think about it, when parents pass away, especially if they are the main caregiver, which they usually are, people aren't going to know automatically that, hey, these are the medications, or I always read a story to my child, or, we go out to eat on Friday nights and it's always at, Golden Corral, or, whatever restaurant, and we do these things. Those sort of intimate aspects of the relationship with that child and their way of doing things can be really super important for a child, and for their, just that continuity, especially in the midst of grief. And so the care plan is a way to express, here are things to take into consideration when you are caring for my child. Yeah.
Awesome. Thank you.
I have a question, one more question. This is Priscilla again. So, when talking about special needs, I do, did have a cousin who ended up having a major heat stroke. And my aunt, who was older, was taking care of her. And her biggest concern was what's going to happen when she passes. And unfortunately, at that time, she was really, based on her age and her health, wasn't able to get life insurance.
Wow.
So, it did end up in a tragic ending. She did pass away from a fall. And so my cousin had to go to a facility. And so one of the things about funding a trust is, one thing I just wanted to share is that it is so important, I believe, when you have special needs, the sooner the parent can properly fund it at a younger age for themselves, if they don't have other assets, is to use a life insurance policy. Because my aunt didn't have any other funds, and she couldn't qualify at the time for life insurance.
Priscilla, thank you so much for sharing that. That is something that I have seen quite a few times with clients where, they come in and they're older, really older, and they are suddenly saying, yeah, we're gonna, we're feeling our age, and we have this child who has always lived with us. What do we do? And it is so much better to have that conversation at an earlier age, when there are things, planning, tools that can be put into place, things that can be done. And, we do the best we can, but, sometimes we just have a tragic result because things were left so late, so yeah. Wow. Okay, that was really sobering, Priscilla. I think you need to share a happy story now.
Happy story. Absolutely happy stories that the reason why, and I appreciate Lucas and I appreciate you, Genevieve, for getting this information out. It is so important. And this is the happy story that there are solutions and there are ways to protect our loved ones, after we're gone. I have 4 daughters, 2 granddaughters, and a third on the way. So, third granddaughter on the way.
Nice.
So I just think it's just so important what you guys are doing. Thank you so much.
You're welcome.
Thank you for your great questions too, Priscilla.
Okay, you guys, I think
All
it's
right.
about time to close up shop.
Well, thank you everybody so much. Again, thank you to both Lucas and Genevieve. That was very informative. And yes, I learned a lot of new information as well. And I'm excited to take this to, more people to be able to learn about it. And with epilepsy, it's a very challenging journey, and anything that we can do to help is very great. So we thank you so much again, Genevieve and Lucas. It was very informative. And if anyone has any other questions or would like to receive their contact information, you guys can go ahead and email me, and then I can connect you guys with them. And then Lucas and Genevieve, if you guys are comfortable to share any contact information as well in the chat, you definitely can do that as well.
Yeah, certainly.
Absolutely.
Well, this was a great way to start off. November is epilepsy month, so this is very great to have you guys be a part of it and to start the month off. And again, anything we can do to, share awareness, as well as, unfortunately, there are a lot of stigmas and myths that go along with epilepsy. So, share the awareness, share the support, and we do have some other upcoming events and programs for this month. So please look at our website as well as our social media for more updates as well. Otherwise, I appreciate everyone for joining us this evening, and I hope everyone has a wonderful night.
Thank you all so
Thanks,
much.
everyone. Good night.
Thank you.
Right.
Thank you.
Bye.
Thank you.
Thanks for coming.